Okay, so welcome to the fourth, I think, lecture on human rights. And what we're looking at today is how human rights can be protected or enforced even. Protected, probably a better word, for reasons that become clear. So I want to look at really three main ways of protecting or upholding human rights. So I'm just going to check this is recording. Oh yes, it's recording. Okay. So the first method would be, if you like, moral pressure. So we'll have a look at that, what we mean by moral pressure and who might be able to exert moral pressure. Secondly, we'll look at so-called international courts and tribunals. And a third way of potentially enforcing or upholding human rights would be humanitarian intervention, although we're going to actually look at that in another lecture, so I won't be touching on that today. But those, just to set this lecture in its context, those will be the three main ways of protecting human rights. Okay, so to begin with, let's look at what I call moral pressure. And really, the UDHR, the Universal Declaration of Human Rights of 1948, doesn't really have any legal power beyond the moral pressure that it applies to states who've signed up to it. Because obviously there's a moral pressure. If a state has signed up to the UDHR, then it's under some kind of obligation to respect the rights contained therein. You know, there's not necessarily going to be any specific physical repercussions if they don't, but if you've signed up to something, then it could, you know, it doesn't look very good if you're not upholding it. As we know, the UDHR was added to in 1966 by the two covenants, one on civil and political rights, one on economic, social and cultural rights. And we can now add to the sort of UN role in all of this. We could add the creation of the UN Human Rights Council in 2006, later followed up with the appointment of a Human Rights Commissioner and a Human Rights Commission. And what the Human Rights Council does is it will actually produce reports on the human rights of different specific countries. So this will add an extra element of moral pressure, naming and shaming countries that are not living up to their obligations under the UDHR, highlighting and exposing abuses and so on. That could be one, the work of the Human Rights Council would be one means of attempting to uphold human rights, but it's what we might call soft persuasive power at work. There's no hard power. You must uphold this or otherwise something bad's going to happen to you. Rather, it's just, that's why we call it moral pressure. It's naming and shaming, exposing, highlighting atrocities and so on, with the hope that that will then encourage countries to change their ways, basically purely out of concern for their reputation, really. And we can see some evidence of the power of the UDHR and the pure number of states that signed up to it, 146, I believe. Most of the world states have signed up to the UDHR. So that does perhaps suggest that it has some authority, let's say, in global politics. But the very obvious limit is it lacks real power to be enforced, beyond just naming and shaming and so on. Another agent, if you like, of moral pressure would be the international human rights NGOs, non-governmental organizations. So this would be groups like Amnesty International, founded in 1961. Amnesty's aim is specifically to encourage states to uphold their obligations under the UDHR. It specifically takes the human rights as listed in the Universal Declaration and seeks to ensure that states uphold those. And there's another good example of a human rights NGO, international human rights NGOs, Human Rights Watch, which kind of evolved out of what's originally called Helsinki Watch, founded in the mid-1970s after the Helsinki Accords, in which the Soviet Union agreed to respect civil rights. So it was originally founded to kind of keep a check on whether the Soviet Union in particular is living up to its obligations. Human Rights Watch is has a reputation for being kind of US, was a US-based organization and being a bit more pro-US, although Amnesty has been accused of that as well. To give you an example of the sorts of methods they will use, similar to the UN Human Rights Council actually, Amnesty will produce reports on I think I'm right in saying pretty much every country in the world. Every year it produces an annual report covering the state of human rights in each country in the world. So again, this is an attempt to kind of name and shame, highlight and expose atrocities and abuses, name and shame the perpetrators with the hope that out of concern for their reputation, they'll mend their ways. But it's not only that, another key campaigning strategy of Amnesty is their letter writing campaigns. So they encourage their supporters to write letters. They'll do these things called urgent actions. I used to do them as a school. You would get, if there was notice that a prisoner was being tortured, or that a prisoner somewhere in the world, someone had been taken prisoner because of their political or religious beliefs, rather than because they committed some specific criminal offence, then Amnesty would encourage their supporters to kind of bombard the government of that country with letters saying, you know, you should release this person or you should stop torturing this person. But also they'd encourage people to write letters to the prison governor and even to the prisoner themselves. The purpose of writing to the prisoner themselves, apart from moral support for the prisoner, is also to show the prison guards and so on that people know about this person has support, and therefore that, you know, there may be ramifications and consequences if this person is, for example, to end up dead or really badly tortured or whatever. So again, it's kind of trying to shed a light on human rights abuses in order to make it harder for them to continue, I suppose. They'll also raise awareness through the media and so on and so forth. So all of this that we looked at so far, the international human rights NGOs, the UDHR, the UN Human Rights Council, this is all soft, persuasive pressure that aims to prevent human rights abuses by exposing them, naming and shaming the perpetrators, with the hope that they will change their ways, stop committing abuses out of concern for their reputation. Basically, that's the principle. Okay, again, of course, they lack real, what we might call coercive power. Amnesty can't force any government to do anything or to stop doing anything. All they can do is try to apply this pressure. Okay, so much for moral pressure. It can have effects. We should say in support of moral pressure. States are concerned for their reputation, and perhaps increasingly so, in a world where arguably, you know, ethical considerations are becoming more important to states, how they present themselves and so on. We can also look at the individual cases that Amnesty gets involved in. They've had many, hundreds of successes where prisoners that they've supported have been released, or people that they've supported on death row have been taken off death row in different countries and so on. So they have had effects, and they do have effects, these kind of campaigns and this kind of moral pressure. Okay, moving on to international courts and tribunals. And there's four really that I want to look at, four types. First of all, the European Court of Human Rights. Secondly, the International Court of Justice. Thirdly, various ad hoc UN tribunals. And finally, the ICC, the International Criminal Court. So we'll take these one by one. First of all, the European Court of Human Rights was founded in 1951. It's not part of the European Union as such, it's something separate. It exists to enforce the European Convention on Human Rights, which was created in 1950, which has 47 states signed up to it. And not just European states, Russia, for example, is signed up. So a large number of states under the court's jurisdiction. And basically, if any state who's signed up to the European Convention on Human Rights is thought to have breached one of those rights, then the victim of that breach, a citizen of the state, for example, can take the government to court, to the European Court of Human Rights, and the European Court will make a ruling. Now, again, it's to a certain extent it's only soft power, because there's nothing really to force governments to actually uphold the rulings of the European Court. They could just ignore them. Nevertheless, again, if you think of governments and states concerned for their reputation, it doesn't look good to be persisting with a certain form of action that's been ruled by the European Court of Human Rights to violate human rights. It's not a good look. So as a result, 90% of the rulings made by the European Court are in fact upheld, and governments will, change legislation if the court demands it, or not stop pursuing certain courses of action, and so on. We've got what's called a 90% compliance rate. So that suggests that even though governments don't have to abide by the court's rulings, 9 times out of 10 they actually do. Again, probably out of mainly concern for their reputation. So this suggests that this is relatively effective in upholding human rights. However, there are some downsides to the European Court. Obviously, there's the 10% of cases that aren't upheld, and the court has no power to ensure they are upheld. In the case of Britain, a very famous case will be the European Court ruled that Britain's denial of the vote to prisoners is a breach of human rights, but Britain ignored that. Some aspects of Britain's anti-terror legislation, for example, the 2001 legislation under Tony Blair that allowed for the indefinite detention of foreign nationals, that was ruled to be in violation of the European Convention by the court, and yet that